other issues defense wanted to address?
There are.
Started?
There.
I'm just bringing the jury in, so tell me what your other issues are.
Ready to.
No, tell me what the issue is.
The issue is we got presented this morning with a host of chat downloads that were purportedly downloaded from the chat account of whom the state purports to be Mr. Demons' chat account. Before she introduces any statements, I think she needs to establish the relevance of it. This is just a download of a series of conversations, and putting them in en masse is a problem. Putting them in individually would require her to establish the relevance of the particular statement she seeks to introduce before introducing it. Our initial review of the contents that she wants to introduce shows relevancy problems, shows authentication problems, and shows prejudice and hearsay problems. So that's what we wanted to address before. We have a copy of what we're presented with here, and maybe we could present it to the court so you can take a look.
I haven't seen it taken a look at it. When do you anticipate presenting it?
Shortly after the first witness, but it's a business record on that. This is, and just so it's clear, this was provided with the initial discovery exhibit that was presented to defense counsel at the initial first ever discovery filing, and that was the season. You will tell me the exact date on that, but I believe that was approximately March of 2019.
So let me ask you this. I haven't seen it. How many exhibits are there? How many are there?
This one's not particularly voluminous. There's a handful of pages, and then there are some video clips and some images. With regards to the images, I brought that to defense counsel's attention because there is one image that is on the defendant's Snapchat account that references some of the more inflammatory song titles. So I was going to tell them I'd be happy to hide that file so that the jury would not be able to access that or see that.
Okay.
And so I can provide those to Your Honor in the printout.
Sure. Has it been marked for identification?
It has not yet.
So why don't we have it marked for identification? And is it possible that you do this or introduce these after lunch so we have a chance to look at them?
No, Your Honor. That's not for time frame on that. Like as I indicated yesterday, due to one of the witnesses having COVID, we would probably have to end early this afternoon, and I beg your indulgence on the time and scheduling on that.
So there's an objection. I need to review it and see what it says. So after, who's the next witness? Yeah.
Tara Kelso, the R.J. Lee.
So we'll talk about it after. Just have it marked as an exhibit, and if you could, just give a copy to Travis after it's been marked, and I'll see if I can take a look at it as we're going. All right?
Understood.
But you said there's videos as well?
Yes, Your Honor. So there are videos.
You're objecting to these videos?
On relevance grounds and authentication.
When we take a break, I'll look. You just play it. We'll see what they're doing.
They're relatively short on the videos. So.
All right. You were indicating that these social media are all from the defendant's account or something like that. Where are they from?
These are from the defendant's Snapchat account, Your Honor. And so I'll have it marked as states J for identification purposes. Presenting to Travis a copy of the business records, authentication and certification, a copy of the printout of the chat records that are in a table format. Everything is contained on a USB I'm also presenting a printout of all of the photos that were associated with the account, as well as a copy of with the photo that could be potentially an issue of the name of the songs taken out, and a copy, a printout of the first part of the, like the first initial clip or the initial frame of every one of the videos on there.
And you intend to play all of these videos to the jury?
Yes, Your Honor, because the defense is contesting whose account that is and whose phone was using this, so that's the state's initial relevance argument.
Thank you. And it's all the same Snapchat account?
It is.
Thank you.
Your Honor, as an initial, just so that you know, a Snapchat account, I'm not sure how familiar you are with social media, but a Snapchat account does not identify a device because it can be accessed from your computer. So I don't think that would be relevant to demonstrate.
Thank you. Let's bring the jury in. So I have, and this has been marked as states JJJ, triple J, and it's a Snapchat account. And so what does this purport to be?
That is the business record production from Snap Incorporated, which is the business that runs the social media app of Snapchat. The records are the records of Mr. Defendant Jamell Demons. They are conversations in statements that he makes, some of which reference this homicide and Cortlen Henry. And there's a specific comment from Mr. Demons to an individual that's identified by a Snapchat name, and it's on there, DHAT is what it starts with, in which he says that Cortlen Henry did something very important for him. I'm paraphrasing from the language on that. In terms of establishing that those records belong to the defendant, the state has to prove that beyond a reasonable doubt to the jurors. So that's why it's necessary to show that all of the photos and videos in that particular item are of Jamell Demons. In addition, the person that he is speaking to, the one that starts with DHAT, that individual, there are images of her that are transferred back and forth. So that is identified as Mariah Hamilton. That is the defendant's girlfriend at the time. She's also in some of the videos. And then there are videos that the defendant sends to her that in which he indicates you shouldn't be speaking on me, basically discouraging her from speaking with law enforcement.
So regarding these videos, how long are they? How many? I mean, you sent me
yes, that's
3 pages listed. I don't know how long these tapes would take a look at.
They're less than 30 seconds each, approximately.
So let's
Sure.
put them in.
The drive that is right there.
Well, yeah, that's fine now. Just has to go back. I want you to sit over there. Is RFP sit over there? Or you... They're good?
I think that might be good.
You can reposition yourself.
Yeah, I'm good now.
Thank you. And feel free to do that throughout.
Thank you.
If there's something showing up on the screen and you think you want a better view of it, you're always welcome.
And this is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that. I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury.
Of
They're
course.
objecting to it, saying it's not relevant. I don't believe there's an objection that's not authentic, that it's not his account from Snapchat. I understand that.
Bless you.
that's the case, but my understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items the defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. The state agreed to get that out. So,
Image of the defendant. An image of the defendant and Mariah Hamilton. Image of the defendant.
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that, I mean...
Correct, that's why the next witness would do that.
Oh, okay, so the witness is going to do that.
Yes, Your Honor. There she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos. This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
that's good.
It's up. That's 63 or 62. There is a volume.
Try VLC.
That was the LC. So.
Oh.
Yeah, I think that one. Sharon, I'll switch over to a different computer. Unfortunately. Very nice.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Your Honor, for the interest of time, should the estate be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what
Right.
my understanding. Well, go ahead.
Okay.
Right. All right, thanks for shit. They need the most important shit here. The most important shit here. Like, get right there, like, you know you come back. You be someone pick up on me. Hey man, I'm 19, I done seen 750,000 each. I ordered it, it'll be a meal. Gotta make sure, it'll be a meal, I make sure. You put saying we'll get out, man. Do it, put saying we'll get off y'all ass, man. Yeah, get off y'all ass, man. Hey bro, don't be speaking on him, bro. He ain't do that. He ain't do that. I bet not about your ass saying you did it.
Those all the videos, Counsel?
Yes, Your Honor.
All right, so, Counsel, why don't you tell me your complete objection so I fully understand what you're objecting to on the videos as well as the remaining portion of this Snapchat under, I think it's AAA.
Your Honor, our first objection would be relevance. I think Florida Statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case. I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat. and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is, or are. But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy objection, or sorry, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence, saying these are all from his phone and therefore they're all his statements, and this is a business record exception and therefore they get in, doesn't cut it. As far as authenticity is concerned, and that's our relevance objection, relevance must be established. I'll cite the court authenticity issues or authentication issues concern Rule Florida Statute 90.901. And I'll cite the court to some case law that doesn't necessarily deal with social media. It deals with text messages and emails. Simonet. I don't know. I can't remember if it's Simonet v. State or State versus Simonet, but it's 100 Southern 3rd 180, which stands for concerns text on a cell phone. And it indicates, these are some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses, and I think this is the only day we didn't get any indication And so there's an element of ambush, but nonetheless, in the Simonette case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange in the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
The Roy versus Skate.
I can print it out if you
I'm
don't.
reading it right now.
I'm not sure what the court is,
It's a PCA affirm.
meaning the language that I'm reading doesn't exist.
Not that it exists, I'm sure it's there. I didn't read the whole concurrence. It's
Okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly. I have.
Oh, you cited it right. 279 Southern 3rd 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it.
Okay.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was. His or her opinion, and there's another judge has a different concurring opinion. There's no specific majority opinion. I don't see one. The other concurring opinion says he reversed, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message that's communicated. No evidence that the texts were recovered from a phone, A, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video or videos here, is also instructive. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicators visually. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191, Southern 3rd, 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding the articulation that is being made repeatedly by district courts of Florida, of this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in. They have to establish the relevance. So we object. One second. So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you. And I misspoke. There was one opinion. It's a PC affirmed on Benjamin v. State, or Benjamin D. Roy v. State, that you cited, 279 Southern 3rd, 238. It's a PC affirmed. There is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right. So, yes, counsel, you want to be heard?
Yes, Your Honor. With regards to, and defense counsel already has the land case, so I'll just provide a printed copy to Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page with notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence, is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue and fact of whether or not he committed these 2 homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individual, that doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, Counsel?
Yes, Your Honor. There are statements there that, in the conversations, that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably. So, context for what? He's having an argument, a discussion with somebody on October 3rd. If they're saying that that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question and issue.
Thank you. I'm going to defer ruling out. Take a look at your cases that you just sent. We're going to take a short recess. Mr. Demons, you need a restroom break? Yes? Can you arrange for a restroom break? We'll be in recess. Thank you. Jurors in the jury room. Counsel, I had an opportunity to take a look at your cases and read over a little bit more about Snapchat. And my thought is this: I understand this defense objection, not be admitting it, allowing the evidence to come in. However, there's a couple caveats. Number one is one of the videos I saw has a gun in it. This is all.
There's access to the murder firearm 6 days before the homicide.
Right. I don't see how that is relevant to anything, and I think it's more prejudicial and probative, and it shouldn't be. All right. So I'm not allowing that weapon. It's not like you had something 15 minutes or a half hour before the incident in question. I'm not letting something in with a gun. Days before. That's number one. Number two, I know there's been no argument that 403 analysis, but I don't see how any of the pictures and the videos with all the flash and the cash and all that really has anything to do with anything. I want all those out. I'm not admitting those. All right?
So the videos of him in the bathroom with the stack of cash
anything where he's flashing all the cash. I don't see how any of those things are relevant. They're more prejudicial and probative. The gun is more prejudicial and probative. I'm not letting it.
Okay, so what I'll do, with your Honor's permission, is I will pull them up here and verify them, because then I would be changing the business records on that. So, but that's important with your honors roll. So that would be these 3 videos in the bathroom. Judge, with regards to this particular video, the second video doesn't have the defendant's picture in it, so just so it's clear. So
the most important shit here.
And so, Your Honor, what I would suggest is that I can modify that video to take out the part where the gun is there, and then, so it would just go from there and then excise the portion where the gun is shown, because that is showing who is speaking and showing who is then showing the driver's license.
It's fine. The gun should be out. It's not.
Your Honor,
It's staged before.
could she at least articulate the relevance of anything? I mean, I understand.
I heard your argument. I understand it.
Okay.
And I've overruled it.
It is overruled.
Overruled. The only thing I'm doing is on 403 analysis, saying that you can't. I don't see the relevance. I don't see the probative value of the gun and the cash being outweighed by overruled.
Defense counsel is also asking to take out the photo of the song and their titles or whichever else.
Right, I agree. Take it out. Murder on my mind.
And so I just need about 5 minutes to fix that video.
All right, we'll be in recess. You work on it.
Thank you.
Yes, sir, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos and pictures, or has the court also decided that all the communications come in without the state asserting a relevancy objection as to each state, or a relevancy as to each state?
Counsel, the videos, my understanding, the videos as well as the written conversations, or you articulated and objected saying they're not relevant and they can't be authenticated and things like that, and the objection is they can't be authenticated. We don't, because how Snapchat works, anybody could have done it. And counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts. It's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not. I'm making that decision. But it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are relevant, saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
Because there's a statement in there which there's state believes is an admission.
Okay, well, if that is the case, then that statement should come in. And if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that we can make an informed decision.
Thank you, counsel. You didn't bring up the fact that there's a, it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with the gun, and I want it out of there. I said the same thing regarding the cash. You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objections overruled. The authentication objection, I'd admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you.
Yeah, if I may have a moment to show defense counsel the clip as it's been
Go ahead.
edited.
We're in recess for a minute. You show whatever you want to show.
All the other ones are already taken out. This is the other one to take out the gun.
And the date. It's a date of these so-called videos on.
Yes, they are on each specific one.
Could I see that diagram again?
Yes, it's there.
May I have a moment to see what this says?
Yes.
I'm unaware.
We're in recess.
The purpose of this is Snapchat account.
Snapchat.
Can you at least identify what you think is a confession in there? Identify it, but I don't understand why you would not identify it, because then you might not make an objection to the rest.
But you probably still want to that.
Yeah, but then it would be admissible based on her theory. Take out anything with cash and do I'm not concerned about that. The judge said take him out. Take him out. If you take him out, don't take him out, then. I don't need to say.
And anything else that's an admission to census? No.
No.
On November
No,
9th.
no, no, no.
On November
You're
9th.
telling me what I'm saying. I'm saying identify what you want in. Because you think it's all admissible to prove that it's his account. If we're not contesting that it's his account, then you're putting in an form of information. Identify what you want in so that we can make an informed decision. If you violate the judge's order, then it's a you problem. I don't need to review it.
Can you make these a copy of this? I know you gave it to me. I'm not disputing.
Yes.
Okay. I'm not trying to be difficult. I know you have it's just problems with it. One or two more times.
Council's going to take you a few minutes.
The video's
Give me a
done.
few minutes. I think Mr. Allison is taking a piece. And we just wanted to be clear that if we
We're in
are...
recess now, so you want to be on the record again?
Yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and juror. Yes, sir?
The state is asserting that among the conversations in state's exhibit, what was it, mark for identification?
Jay?
Triple
J, that there are certain conversations or certain exchanges which she believes relate to facts at issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demons. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state and we're articulating for the court. Thank you.
Thank you. What says the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently put.
Thank you. Can I see you, please? Because there's whole conversations with Ms. Mariah Hamilton that really, that goes to authenticate the whose account it is, but I don't know that it does anything other than that. And can I see the exchange again, please? JJJ.
Oh, I left it right there. I'm sorry.
And Mr. Edelstein had asked me to print another copy for him, so I'm trying to work on that.
I'm sorry.
I apologize.
No, it's my fault. I accept the responsibility. Federal court, I get 2 or 3 points off my guidelines sentence.
So let's get back on record. Again, let the record reflect the approach of the defendant, his counsel, and the assistant state attorney, jury in the jury room. I'm not fully understanding everything that you're saying, Mr. Howard. You're telling me that you're not objecting to the Snapchat conversations. You're not going to argue to the jury in some way, shape, or form that it's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I'm saying that we need to know what she deems to be relevant, and then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account,
Okay.
so that she can get her evidence in, but to get the rest in. Your Honor,
No problem. We'll just leave it the way it is.
Okay. There may be another issue, not as though you don't have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B, and the state wants to get A in and knows that the witness's current position is B. put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court, stand for that position. Dudley v. State, 545 Southern 2nd, 857 Florida Supreme Court, 1989. Felton v. State, 120 Southern 3rd, 126 Florida 4th DCA, 2013. Curtis v. State, 876 Southern 2nd, 13, Southern 2nd, 13, and that's First DCA, 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have them for a state as well?
I do indeed, if I may.
Take a look, whatever you have.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes,
All right, so it is Ms. Holmes? And,
not Ms. Hamilton.
Felicia Holmes, sorry.
And what do you anticipate Ms. Holmes saying?
Judge, I believe she'll testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct Your Honor's attention to 90-803 subsection 5, past recollection recorded, in which a witness who no longer has a memory of an event but has previously given a memorandum or record as to what happened, they may testify as to lay a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better. It was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 90-803 sub 5.
So you're telling me you've spoken with her, in a pretrial discussion with her, and she said she has no memory of what she said at the time?
There are parts of which the statement she does not recall. That is correct.
May I retort?
Sure.
Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is going, that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify, then the pretext that she comes in here and says something different and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Much more recent than that, no?
22. Yeah.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior inconsistent statement it's a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior inconsistent statement or an out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
Thank you. Anything else, ma'am?
Just the record's clear in her deposition and counted. She says, I don't remember, or I can't remember, approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember, so that 98 or 305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least two of the three.
And what's her statement, counsel?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or what you believe she's going to testify to, or if she doesn't remember what you are going to try to refresh her recollection?
So she says that she was woken up at 4 in the morning. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Demons then says he was saying that Mr. Demons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Demons, are you okay? His response was, I'm okay. She then asks him where are Sack and Juvy, the common nicknames of the two victims, and he said, I don't know if they're in the car, I think they're dead. So she then says, you think they're dead. She then goes through and describes her actions and conduct. She said that she called his mother, Jamie. Oh, I wouldn't go into the contents of that conversation because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Demons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Demons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then says shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Demons, Cortlen Henry, and Cortlen Henry's girlfriend are living together in a condo in Miami. She's going to testify that she didn't, and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The question is asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed, and her answer at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Demons, and he never called, there was never. Then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, that you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z. She's saying she doesn't remember.
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Your Honor, before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent. In the Curtis case, 876 Southern 2nd 113, which was a First District case in 2004. This is the language. It says, Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to Section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says, one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down. It says, in a similar situation, the First District Court of Appeals in Austin v. State, 461 Southern 2nd 1380, Florida, 1st District, 1984, found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, to call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. The district court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under Section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says, the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State, 120 Southern 3rd, 126, 4th District, 2013. The language that we're relying on says, in Ruff v. State 31, Southern 3rd, 833, Florida, 4th DCA, 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who has previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with the balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State 689, Southern 2nd, 259, Florida, 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 in the morning concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receiving from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. And we object.
All right, anything else? Madam State?
No, Your Honor.
So we're going to bring the party in, we're going to see where it goes. All right, I understand what the objection is. God bless. I understand what the objection is. We'll see where it goes.
All right.
All right, let's bring the jury in.
Those aren't the same statements that we're looking at.
No, phone call, she's going to do. Sure.
Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Yeah, all right, hold on.
put in through this witness.
I'm sorry, what were you handed, counsel?
Counsel has been handed and was previously provided a portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior, in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of these conversations. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, which is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well
as being a phone that Mr. Demons used.
Correct. So, and there are two first pages, because if you look at them there's a section in green where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that that would be prejudicial to the defendant, so I created a version in which that specific item is taken out. So if you look at the green birthday and then just the first page and the second page, or if you look at one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated?
No. He knew and was made aware he was going to be serving a sentence in Lee County, because that was a negotiated resolution. So instead of saying third birthday I'm going to be locked up on, WTF, instead I just put third birthday, and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those, do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Janie King is out there. Then there's the phone number down here that's part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes, that are all listed on there.
And the state has not articulated a relevance of even establishing Miss Holmes or Miss Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? They might as well establish my phone number. What does it matter? If it can't be tied up, or if it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Miss Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there are several phone conversations there that do not involve the witness they're about to call, and for those phone conversations to come in through that witness is just improper. How does she even lay the predicate to that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
When you say participants,
Correct.
does she know who the participants are? She's a party to this?
She is. She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content
who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever judgments you think are appropriate, Counsel.
Okay, sir. Thank
I'm
you.
sorry, is there something funny?
Pardon me?
Something funny?
Not at your ruling. Your Honor, I mean no disrespect to you.
All right.
And
Let's bring the jury.
I hope you don't get that impression.
Let's bring the jury in.
Thank you.
Jury entering?
Thank you. So what do you anticipate this,
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, cuz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and you know, he never called it. There was never, answer. You have the 772-713-9807? Question, 9807. Answer, I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
so assuming that I let this portion in, is this going to be a reoccurring theme that, what else are you going to ask her about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, yeah, he's like, yeah, there's some. I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Sack and Juvy? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito Bang or Frederick Gibbons is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer. It's like I don't know. And I said, we're on our way, just so you know, stay put, we'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned she she may or may not remember?
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically, the portions that you just elicited.
Yes, Your
Correct.
Honor. And I can I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from now? What are you reading from now?
I am reading from her statement of December 12th of 2018.
You're reading from a statement, not a deposition.
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority, and you're making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decisions or not. Her deposition of December 14th, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock in the morning. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and first thing she said there, she's not talking about Jamell, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to, and the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and admit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases in murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get the statements that they're not committed to get.
Thank you. You have the statement of Ms. Holmes as well?
I do, Your
And that
Honor.
was taken under oath?
It was, yes, it's a sworn statement from Ms. Oath, from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the time frame and issues of that Those were actually clarified because defense provided the state with reciprocal discovery of Miss Janie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Janie King. That is shown in Miss King's phone records.
Who's Jamie King?
The defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take the statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
The state can do under these circumstances. It's in the interest of justice rather than to have a witness who, for various reasons, is now professing a lack of memory to then be prohibited from introducing substantive evidence in the case.
So you're calling a witness that has testified that the witness doesn't recall, and you're suggesting that I take it that she's feigning a lack of memory?
On some of them, I think it's accurate that she doesn't have a verbatim recollection of what was said. I think if she said that she did, that would be suspect. I think so. In terms of having a better memory back in 2018, 2 months after the incident or less than that, that is valid, and that she had said she was truthful with law enforcement at that time. So the state has met the admissibility threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay, and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that her, and I think advised in bad faith, that her daughter might be charged as an accessory after the fact, when there was no evidence to suggest that. And she said she was acting then under threat, and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida as explicitly outlined in the cases we cited and numerous other cases. So that's why we object.
Thank you. So, Counsel, I've looked at a couple of cases that came across. First is 880 Southern 2nd 561 Pierce v. State, Supreme Court of Florida, and the second 993 Southern 2nd 1108 Fort DCA case SL versus State. And in the first case, the Pierce case, that was an issue whereby during cross-examination of a state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence, and the state, his response was he didn't recall, don't remember, anything along those lines. And the end result was that the Supreme Court said in order to resolve this claim, and I'm reading from the 8th page of the opinion, it said in order to resolve this claim, we must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. Second case I have is SL v. State, as I said, 993 Southern 2nd 1108, and that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. And it goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. It doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness denies remembering the statement and you want to read it to him, I don't see how a curative instruction telling a jury it's only for impeachment purposes and not as substantive evidence is going to resolve it. So my thought would be just to keep it out. So I'd sustain the objection.
So just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection recorded, which is a very specific subset. So I refer to Earhart on that specific issue, 9803 sub 5.
Excuse me one second. Could you get my earphone? I left it on my desk. Council, what section are you talking about?
9803.
In your order.
Yes, subsection 98035, which in the 2022 edition starts on page 1104. Citations. I provided a copy to defense and a copy for your honor. And the light is located at 116 7th 3rd, 270 Florida Supreme Court, 2013.
All right, I've read the case. Anything else you wish to share with me, Counsel?
No, Your Honor.
How about from the defense? Anything else?
The commentary on the case that was just provided.
Yep.
I think the polite case, the very first head note, says that the admission of the past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind,
That's done.
and also attest to the accuracy of the memorandum or record. The opposite of that was done.
Excuse me, and that's in the bottom as well. That you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, "We reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection recorded under Section 98.803 subsection 5 requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind and also attest to the accuracy of the memorandum or record." Then it goes on in conclusion. In this case, a proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
I have nothing further.
Counsel, my thought is this. If what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect, if that's what she continues with, I'm not going to allow you to admit the evidence. All right?
Understood.
So, are you ready to proceed?
Yes.
All right, let's bring the jury. You're ready as well?
I'd just like for the court to order this witness off the stand. I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose, and they're compounding the prejudice by having her remain there. I think that the state has something that's admissible that they can prop to this court, that witness testimony needs to be concluded.
Thank you. They will be heard.
Judge, the state's not.
Pardon?
There's additional. The state's not.
Pardon?
There's additional information and things that's open to being talked about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state, I guess pursuant to this hearing where she was, I think you said she was in islands?
Yes, sir.
Regardless, so I'd allow that. The problem I don't want to happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was, that they're on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that that statement was accurate, so it's not getting in under recorded recollection, and it's not getting in as impeachment because it's not. It's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections.
So is your
So I don't want you to get in the back door, but you can't get in the front door.
No, just to make it clear,
Is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or-
I didn't
okay.
say that. What I said was, the statement's in the police report, right? You can't just have that, read that back to her. Didn't you say this to the police officer? I don't want that being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And
Understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollections reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
she'll ask whatever questions she thinks appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate because she's not subscribing that this is what that statement is truthful, so I don't want you to just be regurgitating the statement and asking her that. I don't want that done, and I don't want you to do, anyway, we'll see where it goes.
Yeah, just one thing, Your Honor, I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's going to get a no, and she's just putting it into the record. It's improper. And I've
Hopefully I
asked,
made myself clear, but that's why she's going to be able to, counsel's going to be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just going to rule her to go forward like that. I don't know what you intend to ask counsel. I just don't want the contents of that statement, regurgitation of that in some form of leading questions, all right? All right, bring the jury in. Let's get the witness back in. What did that? I don't know. Let the record reflect the jury stepped down. Counsel remain along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that I don't know if I don't think there was any evidence that she had something that might have been marked as an exhibit.
It was not marked, Your Honor. It was just a copy of the
So
transcript.
you're okay with it?
Yes, Your Honor. I have plenty of copies.
All right. In any event, so jury's been excused. Counsel remain along with the defense. So you have a couple motions from this trial. You want to talk about those?
yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, advanced a ruse, pretext that they were seeking to do so under 8035. it turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that means.
This is your motion for Mr. Alistine?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or Mr. Demons' interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about the motion for mistrial. I think it's appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But you talk to your client about it. We'll see everybody back on Tuesday. All right?
Yes, sir. Have a good weekend, sir.
Judge, since we're breaking early today, can we have a few minutes with our client?
Sure, I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off for the
I
possibility?
can't hear you.
The camera's off.
Oh, you want privacy, that's fine. The cameras can be excused. They can go out of the courtroom.
Thank you.
Guys, everybody can go out of the courtroom. All right?
Thank you so much.
Thank you.
Adjourn. This is like a private conference area.
Thank you.